Supreme Court Judgment Number 7488/2541. This case, the plaintiff filed plaint as administrator of an estate of S. The testator claims that the disputed land, which the civil court ordered, is the ownership of the defendant number 1 by the possession, that is, the ownership and estate of S acts to the cadastre to lives, the registration of the ownership as stated to the defendant as follows. In the case that the interpleader has insisted that he was the descendant of A to divide the estate from the third litigant under the Code of Civil Procedure, Section 57, Paragraph 1. From this, the plaintiff, who is the executor, must have a responsibility to all of the descendant as if they are the represent under Civil and Commercial Code, Section 809 to 812, 819, 823, and 831, consist with Section 1720. So the interpleader will use the right of interpleading to be the third litigant for defense his represent under the Code of Civil Procedure, Section 58, Paragraph 1. By the time the represent or plaintiff, who is the administrator of an estate, are filing plaint for repayment from the third party or both of defendants, so this is an illegality. Moreover, if court understand that the disputed land is not an estate, the interpleader petition are useless for the circumstance consideration, then it is not necessary to receive the protection or enforced by the rights that may exist in the civil court to cancel the interpleader petition. The plaintiff filed plaint stating that the plaintiff is statutory here, and Mrs. Sang Namasongthi executor or Lady Sang Si Sonrat, the dispute land title deed number 227 is styledคลองซอย2 ซอย 2 Sub-District คลองหลวง District ปทุมธานี Province, give them to the first defendant just to make benefit from the land. Afterwards, the first defendant and the second defendant ask for a legal title by possession and give the false fact until the court of first instance taken in asks for the judgment that the order of the court of first instance are not binding, with the plaintiff acts to the cadastre at Klong Luang District Branch, Pathum Thani Province, to leave the registration of the ownership for the first defendant to judge that Mr. Sang Namasonthi or Lady Sang Si Sonrat have a proprietary right to the disputed land, and both defendants and National Housing Authority to December 2527 are not binding with the plaintiff. Both defendants gave testimony that the first defendant possessed the land with ingenuousness and intent to possess this land more than 10 years. The Court of First Instance judged that the disputed land is the first defendant ownership and the plaintiff is not a descendant of Mrs. Sang. Thus, the plaintiff plant is repeated and expired. There is no reason for National Housing Authority to restrain the development of adaptation for this land. During the considering, the 11th interpleader filed a complaint to be litigant. The 11th interpleader is a statutory heir of Mrs. Sang. They are her great grandchild. Even plaintiff is an administrator of an estate, but the plaintiff did not act for the benefit of the other heirs. The plaintiff intended to take the disputed land from that the 11th interpleader have to interplead to receive the protection of their rights under the Code of Civil Procedure, Section 57, Paragraph 1, and asks for the judgment to divide the land by the 1st to the 9th interpreters have one part, and the 10th, the 11th, and their friends get 1/2/6. And the court of first instance ordered that the 11th interplead by the right of Mrs. Sang Namasonti's descendant, who is the testator of the disputed land. But the plaintiff implied this case at the administrator of an estate and implied in the name of heirs, so they are not necessary for the 11th interpleters to interpret in this case anymore. For the last request, the interpleading number 3.3, the 11th interpleters have to negotiate with plaintiff beside the case. Accordingly, the interpleading is over. The interpleters take upon themselves. The Supreme Court decided this case. The plaintiff sued as administrator of an estate of Miss Sang Namasonthi, who is the testator, asked to the judgment that the disputed land is the descendants' estate. Court of first instance order that an ownership is the first defendant. However, the hostile possession is still an ownership of Mrs. Sang's Namasunti, who is the testator as to the cadastre that Klong Luang District Branch, Pathum Thani Province, to left the registration of the ownership as follows: the first defendant. Then the 11th interplayed as the third litigants under Civil and Commercial Code 809 to 812, 819, 823, and 831 with Section 1720. For this reason, the interpleaders will use the interpleading right as the third litigant to defend against their own represent implicitly under the Code of Civil Procedure Section 58 paragraph 1, while the represent of plaintiff as administrator of an estate are feeling plained for repellent from the third party of both of defendants. So this is an illegality. Moreover, to understand how the disputed land or estate should apportion, or who is the other descendant, it would be after dispute. It would be after this dispute case between plaintiff and defendant that is an estate or not, and if the court understands that the disputed land is not an estate anymore, the interpleader request and petition are useless for the decision. The circumstance is not necessary for the protection or enforced by the right that may exist in this court judgment affirmed.